There are many ways that your criminal case can be resolved in state court in Oklahoma. However, most of the resolutions in a criminal case fall under one of three categories. First, your case is resolved by an agreement. In most cases, the state has filed charges for a reason. Those reasons typically involve some level of culpability against you or your loved one. And many times, the district attorney or the prosecutor in the case will agree to some type of resolution less than what the potential negative outcome would be, whether it be probation or some type of deal in your case that avoids jail or prison time. Oftentimes, due to the volume of cases on their docket and your willingness to cooperate for judicial economy, for their benefit, and to avoid witnesses having to testify or potentially victims, if victims are involved in the case, the district attorney will often agree to resolve your case without trial for a deal far better than what you could get if you went to trial. One of the great benefits of having an experienced and reputable criminal defense attorney in your case is he or she can help you to obtain the best deal possible through mitigation, extenuation, and showing what led you to be in the place you're at in your life, whether it's substance abuse related, mental health condition, or other factors that weighed into your life that led to the decision you made that led you to be the place that you're in. However, many times we have clients who are not guilty of what they've been charged with or not guilty of any offense. In that circumstance, that leads to the second option, which is fighting your case. We are personally fierce advocates for every client that gives us the honor of representing them, and we will seek to fight and have your case dismissed if that is the right course of action. The power of accusations is an incredibly powerful thing, and if one person makes an accusation against you, you could stand and face criminal charges for what they're alleging that you did. In those instances, we try and build our clients' evidence in the case, relevant witnesses, potentially a defense or an alibi, or other circumstances that lead to the fact that it was impossible that you did what you did, you did what you allegedly did, or whether the complaining witnesses changed their mind or come to the reason about what they allege that you did previously and maybe potentially determined that they misrepresented things to law enforcement or law enforcement misrepresented things to the prosecutor. There are many ways to seek to fight your criminal case, and we try and identify the facts, evidence, circumstances, and law that indicate that you should not be charged with either the offense that's pending against you or potentially, if you're actually innocent of any charges, try and have your case resolved either by agreed dismissal or by fighting your case in jury trial. Third and finally is a case that's resolved by the court. There's really two variations of that. First is a diversion program, such as the Veterans Diversion Program, drug court, mental health court, female diversion, delayed sentencing programs, community sentencing, DUI court, or a few other circumstances that allow you to resolve your case without jail, without prison, and without an actual adjudication of your case. There's a variety of these available. They differ county to county, and it's important that you and your criminal defense attorney are aware of these options and pursue them if they're a good option for you and your specific circumstance. Additionally, is another way for the court to resolve the case, which is called a blind plea. In a blind plea setting, you would enter a plea to resolve the charges pending against you. However, you would not have an agreement with the state or the prosecutor. In that circumstance, you and your attorney will present evidence and argument to convince the judge that you should receive a lighter sentence than what the prosecutor is recommending for a variety of reasons. And the prosecutor, conversely, will often make recommendations as to why you should receive the sentence that they recommended you. And unfortunately, in some circumstances, the prosecutor will ask for a harsher sentence at a blind plea than what was negotiated at in your case. We try in every circumstance that we're going to have a client pursue a blind plea and let the court decide the outcome to get the district attorney or the prosecutor to agree to a limit for what they will ask for. Now, keep in mind, that does not bind the court. The district attorney can recommend A, your attorney can recommend B, and the court can go above and beyond what either party asks for. It's an important consideration, an important fact to know under the criminal law and criminal procedure of Oklahoma. However, from my experience, in the many cases I've represented clients through a blind plea process, I found in the vast majority of those cases, the court will cap the negative outcome that it will give at what the district attorney asked for. A common circumstance is an office policy or just an unwritten rule for a specific office that they will ask for a conviction or some amount of jail time in every single type of a case, whether it be a domestic violence charge or a DUI that's aggravated based on the amount of alcohol consumption. However, that's not necessarily the proper outcome. The legislature has given a number of offenses the opportunity for the court to sentence someone to probation without a conviction or probation with 0 jail time. And in those circumstances, if the facts and the evidence and your history warrant it, we will ask the court to give you the opportunity for no conviction, for no jail time, in terms of probation in your case, to allow the court to resolve your case without jail or other negative consequences. If you have more questions about these 3 options, that one, briefly, is to resolve your case by some type of agreement with the prosecution to avoid the potential harsh outcomes at trial, or 2, to try and fight your case through various aspects of litigating a criminal defense case, or 3, by resolution of the court deciding the outcome, or through a program. I hope that this has been helpful in explaining how the vast majority of state criminal cases are resolved. If you have more questions, I encourage you to subscribe to our page for regular updates on these and other criminal defense issues. Thank you.